The Canadian Supreme Court finally made a ruling on the case of R versus Sullivan, in which the defendant Sullivan argued that Section 33.1 of the Criminal Code of Canada was unconstitutional. The courts agreed. To understand this case a little bit more and why the courts ruled in Sullivan's favor, we need to understand what Section 33-1 of the Criminal Code says. Section 33-1 of the Criminal Code of Canada has 3 subsections, and here they are now. When defense is not available, subsection 1. It is not a defense to an offense referred to in subsection 3 that the accused by reason of self-induced intoxication lacked the general intent or the voluntariness required to commit the offense, where the accused departed markedly from the standard of care as described in subsection 2. Subsection 2. Criminal fault by reason of intoxication. For purposes of this section, a person departs markedly from the standard of reasonable care generally recognized in Canadian society and is thereby criminally at fault where the person, while in the state of self-induced intoxication that renders the person unaware of or incapable of consciously controlling their behavior, voluntarily or involuntarily interferes or threatens to interfere with the bodily integrity of another person. Subsection 3, the application of the law. This section applies in respect to an offense under this act or any other act of Parliament that includes as an element an assault or any other interference or threat of interference by a person with the bodily integrity of another person. So in non-legalese, if you are intoxicated to the point of losing control over your own actions, it is unconstitutional to find you guilty of an offense in which you violated someone else's bodily autonomy. Basically, if the court finds that you could have not voluntarily made the decisions you made, you can't be found guilty of a crime. That sounds insane, so why did the court overrule this law? The Supreme Court found that Section 33.1 violates the Charter of Rights and Freedoms, specifically Section 7 and 11D. And what do these sections say? Section 7 of the Charter states, quote, "Everyone has the right to life, liberty, and security of person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice." Section 11D states, "Any person charged with an offense has the right to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal." Combined together, the courts say that the defendants had the right to make the defense of autonomism, which is the defense in English common law that effectively states that a defendant that was not aware of their actions could not have the intent required for criminal liability. Common examples of this are as a defense for sleep terrors and accidents related to those. So what exactly does this ruling mean? Well, it means that intoxication and automatism defenses must be accepted in cases in which the defendant voluntarily took a substance that caused them to lose voluntary control over their actions. There are some pretty dark examples that I think should have been considered before this law was struck down. So this is your content warning in case you don't want to hear about sexual assault. A dude goes into a bar. He gets wasted drunk. He then rapes the bartender on her way out after shift. If that dude can establish that he was not in control of his actions, he cannot be found guilty of rape. Here's another theoretical. A lady, high on meth, breaks into someone's house because she thinks she's being chased by demons. She turns around and punches what she thinks is the demon in the face, but it turns out to actually just be her elderly neighbor. Her neighbor dies of head trauma because she hit her head when she falls. In this case, under the new rules, the lady high on meth is not guilty of murder or manslaughter. The defendant would be found not guilty citing special circumstances, and it would be seen similar to like a insanity defense. This is a backward slide in the fight for establishing justice for wrongdoings. Justice will not be had in these cases unless the House acts immediately to write new laws that are in line with the Charter. Our members of Parliament need to act now, and they need to act quickly. I just hope that this decision by the Supreme Court isn't used as an excuse for that slippery slope of decreasing accountability. Thank you for watching the show. If you enjoyed it, please leave a like and a comment. And if you really enjoyed my content, check out my socials on the end card and subscribe to the channel. Until tomorrow, everybody, have a fantastic day, eh?